Hill in the matter of KSY UK and Citrosuco.
Yes, Ms. Larty, good morning.
Good morning. So as you say, my name is Ms. Larty and I represent the appellant KSY Juice Blends, and the respondent Citrosuco is represented by my learned friend Mr. Corby.
Yes. Thank you very much for this very well prepared case and for your interesting arguments. Have you had a chance, we've read quite a long way into it, have you had a chance to discuss with Mr. Corby how the day is going to be divided up?
Yes, so broadly we've agreed that I shall have 2 hours and 2.5 hours and he shall have 2, but with some flexibility. So if my learned friend needs more than 2, he can have more than 2, if that makes sense. So I shall aim for...
Well, he can have more than 2 provided he says, remember we will finish at 4:15.
Yes, agreed.
So
essentially what we've agreed is no one will have their stopwatches out. So I expect I will take 2 hours.
I may have mine out, Ms. Larty.
Sure, I see that. We will not go past the 4.5 hours, okay. But I've agreed that if I open for 2 hours, then if my learned friend was to need a bit more than 2 to respond, then as long as I have sufficient time to reply, okay, right. If that makes sense.
Well, let's see how we get on. Yes.
Also, there are transcribers.
Yes, that's being done via the live stream, I think. Is that right?
Yes, that's correct. And they've asked for a break at 1.5 hours and then 1 hour off for lunch, which I'm sure we can accommodate.
Well, we'll have an hour for lunch. How long do you want? 5 minutes? Would that be sufficient?
They've said 10 minutes for the interim break.
Well, let's see how we go, shall we?
Yes.
Because obviously, I appreciate they will need a break, but we must finish this case today. There's quite a lot to cover.
Yes, I agree.
Thank you.
Well, they can hear me. I'm not sure they do need a break. It's regularly asked for, and in my experience, it's now regularly declined, and they seem to manage.
All right, understood. I'm sure they will...
They will have heard that.
Yes. Well, thank you. So to start, I'll just jump straight right in, unless there was anything else that your lords needed to...
Thank you.
Yes, all right. So as you will be aware, the appeal concerns a contract for the sale of orange pulp wash, or wesos, which was entered into by the appellant as seller and the respondent as buyer back in 2018, so May 2018. And the question for your lordships is essentially whether that contract is an unenforceable agreement to agree in relation to 2/3 of the contracted 4 volumes. The grounds of appeal can be found in the core bundle at tab 1, if you have tabs. And it's grounds 1 and 2 that we're concerned with. The trial judge did not grant permission in relation to ground 3, and his refusal is at tab 7, page 142. And there's some disagreement between myself and my learned friend about the relevance of that, and I will get to that in due course as necessary. But briefly, in my submission, the trial judge considered that the ground 3 issues could be covered by grounds 1 and 2. By way of roadmap, I intend to structure my submissions as follows. First, I will provide a brief introduction, including taking you through the contract or some of the key provisions in the contract. It is very short, and showing you how the relevant part of the case was pleaded by the appellant, just to show you the phraseology of the implied term. Second, I will address the key applicable legal principles, including looking at the Court of Appeal judgments in Mammoth Oil and BJ Aviation, which are the leading authorities. And I will also I intend to look at Mammoth Oil in some detail, because it contains a summary of the case law that came before, and including cases like F&G Sykes and Hillas and Arcos, among a few others which are relevant here as well. And in that context, I will address the question of whether I can have the benefit of Section 8, subsection 2 of the Sale of Goods Act, which provides that where the price is not determined by the contract, a reasonable price must be paid. And I say I can have the benefit of that, though I can in any event establish an implied term that in the absence of agreement, a reasonable price will be paid. And I will explain that as well. Third, I will apply those legal principles to the facts of this case and address what I say is the central question here, namely whether the words open price to be fixed at clause 5 of the contract are inconsistent with or exclude or preclude an implication that in the absence of agreement, the price is to be a reasonable price. And I essentially have 5 points to make there. Fourth, I will address uncertainty outside of the agreement to agree question, i.e. whether a term that a reasonable price be paid is in any event too uncertain to be implied on the facts of this case. So not because of there being a potential agreement to agree, but for other reasons, for some other uncertainty. And this question, of course, only arises if I am wrong about Section 8.2 of the Sale of Goods Act. Fifth, I will address some remaining points arising out of my learned friend's skeleton argument, which I will not have addressed already. And finally, I will briefly address whether I can succeed purely on the construction of the contract and also the reasonable endeavours case. But I should say at the outset that I am realistic that if you are not with me on the Sale of Goods Act or the implied term question, you are unlikely to be with me on those points. So I will be very brief in relation to them. So,
is your implied term point, apart from the Sale of Goods Act, an implied term as to market price or as to reasonable price, or both in the alternative?
So I will get to that. I can address that now, in fact, if it's helpful. Essentially, it may be, it's a reasonable price or market price if different. So what I will be submitting is that there's a standard way. So the price for wesos is linked to the price for FCOJ. So there's no sort of list price for wesos, there's a list price for FCOJ. And then the standard approach is to take 70% of the market price for FCOJ to identify the price of wesos. And so there was always a question in this case as to whether it was therefore appropriate to describe the price as a reasonable price for a market price, because it was always my case that there was no available market within Section 50 of the Sale of Goods Act. But whichever way it is phrased, way it is phrased, it is certain enough because there is a standard approach to ascertaining the price via the market price for FCOJ. So if I turn now to a brief introduction, and given timings, I will be brief. The contract is at tab 11 of the core bundle, and I will just take you through some key provisions in that. So that's page 190 of the core bundle. So as you see there, the appellant is the seller and the respondent is the buyer. At clause 1, we see the product orange pulp wash, and which is explained at paragraph 5 of the judgment, is a byproduct of the orange juice manufacturing process, which can be used in, for example, soft drinks, the production of soft drinks. It has a shelf life of 12 months, and that's all in the judgment at paragraph 6 and 7. Clause...
Just pausing for a moment at the parties. I think the judge described KSY as a Greek company and the buyer as a Brazilian company. Did he mean that, or did he just mean they were English and German or Austrian subsidiaries of groups who were based in Greece? And
I think that's probably a little bit of an inaccurate description from the judge. But the sort of head company, for example, of Citrosuco is in...
The KSY Juice Blends UK Limited is an English company,
yes.
And Citrosuco GMBH is what, an Austrian?
Yes, I will be corrected if that isn't correct, but my understanding is that it is, yes. Yes, my lord. And the other key provisions are clauses 3, 5, 6, 9, and 10, which are over the page. So clause 3, price. You see their invoicing price, €1,600 per metric ton. Price adjustable according to bricks. Free trucks will be offered from the seller according to the agreed volume and price of each year. Calculation basis for the 1,200 metric tons fixed is €1,350, which corresponds to the 400 metric tons per year, 2019, 2022, and 2021. And once I've gone through the contract, I'll briefly explain bricks and free trucks. But essentially, those are the price provisions. Then clause 5, delivery period, 1,200 metric tons per year, deliveries to start January to December with the following split. And then you see the 400 metric tons fixed and the 800 metric tons open price to be fixed latest by December. And it's that phrase, open price to be fixed, as well as agreed volume and price at clause 3 that my learned friend relies on.
Do we just need to pause on paragraph 4, which provides different options for deliveries, maybe at Venlo, or it may be in Ghent, and it may be in bulk, or it may be in drums.
Yes.
Now, the price is not dependent on which of those it is.
I think I know where my lord, where you're going with this, which is that
I'm not necessarily going anywhere. I'm just trying to understand what you say the contract means.
Yes, so there are, my apologies, there are options. Yeah. In practice, X Works bulk Venlo was the one that they tended to go for. But when the instructions were given by the buyer, they would of course identify which of those options they were going for.
Yeah. But the price is the same?
The price is the same regardless, yes. So delivery period, so we see the deliveries are any point between January and December, and then we'll see that the buyer has to give 15 days notice. So anywhere in that 1 year, at 15 days notice, they can demand delivery of goods. Quality criteria at clause 6, as per approved sample, bricks reference minimum 50, so we see bricks again, and other quality criteria, ratio, acidity, and so on. Over the page, clause 9, instructions for dispatch. The buyer should inform the seller 15 days prior to every delivery. The buyer is obliged, that's not so important. Clause 10, quantity, 3,600 metric tons, and that's of course very important to my case. So that is the 1,200 metric tons over the 3 years. So it includes the 400 metric tons per year at 1,350 euro, as well as the controversial 800 metric tons open price. So 1,200 times 3 is 3,600. So that's how you get to the 3,600.
But that wasn't in fact the amount to be delivered at all, was it?
Well, the amount that is dependent on the free trucks mechanism, which I will get to. It would never be less than that.
Is it right that the one thing that is fixed by this contract is the amount to be paid under it, which was 1,600 euros per metric ton for 3,600 metric tons? So
the invoice price.
The bricks adjustment.
Yes. So the invoice price, and one of my arguments at trial was that the 1,600 invoice price is a sort of fallback, but that was rejected.
Leaving that aside,
yes.
Is it your case that the contract does provide for that amount to be paid to the seller under this contract? That the 1,600 plus or minus the bricks variation multiplied by 3,600 is the price to be paid over the course of this contract? Well,
so the way that the invoice price is calculated, so you get charged that price, and then you get free trucks on top. So in effect, you're paying less, but you are paying that amount.
Well, you either pay or don't pay a certain amount. So the buyer pays that.
Yes.
It may be receiving more trucks. Sorry, not more trucks.
Precisely. So you pay.
Product.
So I have a simple example using simple numbers. So you agree to buy 10 metric tons at an invoice price of 100 metric tons per £100 per metric ton. The agreed price is £50 per metric ton. You are invoiced at £1,000 for 10 metric tons, and you have to pay that amount, which I think is my lord's point. And then on top of that, you get another 10 metric tons. So you have paid £1,000, but you have actually received 20 metric tons. So you are in effect paying £50 per metric tons, but you have paid. Yeah.
So the variable here is not the actual price paid. The money paid is fixed by the contract. The variable is the amount you get in return.
The quantity.
Well, yes. Well, you could put it in that way, or you could say you are paying in my example, you are paying the invoice price for the product, and then separately you are getting some free product.
Why do you put it that way?
Well, my point is just that you could put it either way, but you could either put it as the free trucks amending the effective price, or you could say that you pay a set price and then get free volume on top.
Well, I think my Lord's point is that that's what the contract says. The price is fixed. The invoice price is clear.
Yes.
It's the quantity which varies.
Well, the quantity for that invoice price is the quantity for that invoice price, and then you get some free product on top, or the quantity varies and the invoice price remains the same. You can either look at it as this is the product I'm getting for this price, and then separately I'm getting some free product.
If you leave aside the term price and
Yes.
replace it by amount paid,
Yeah.
I think my Lord's point is the amount paid
Yeah.
is fixed.
Yes. That's
If
yes.
you treat price as a variable according to quantity, then
Quite.
Okay.
then you can.
Fixed amount, variable quantity.
Fixed price, variable quantity,
Okay.
or variable effective price.
Well, let's see whether that has any material
Yes.
bearing on where we go. Okay?
All right. So the quantity certainly for that price at the invoice price is 3,600 metric tons, and it will never be less than that.
It will always be more than that
It will always be more than that.
because you've already got your fixed price for 400,
Yeah.
and that is always going to involve free trucks.
Yes. Well, unless the market price is exactly 1,600 euros.
No, but even if it is, for your 400 metric tons,
Oh yes.
it's 1350 for all 3 years.
Yeah.
So there'll be free trucks for that 400
Yeah.
every year, irrespective of what happens to the market.
Yes, that is true. Yes. Because it's below the 1,600. And then,
So the quantity will never be 3,600. It will always be more than that. On your case.
well, yes. Yes, it will always be, the amount delivered will always be more than that. Yeah. So I think BRICS, as I think this will be uncontroversial, is basically a quality criteria. And it can also be used to adjust the price. So you price at an estimated bricks, and then you adjust for the actual bricks. And I think I've given you my example of how the free trucks mechanism works.
Can I just press you on that? You adjust what? You adjust the invoice price, or you adjust
The invoice price is
the
adjusted
amount you get?
for bricks. Apologies.
So suppose your invoice price is 1,600 euros
Yes.
for 60 bricks.
Yeah.
Suppose that when it comes to be delivered, it's only 55 bricks.
The invoice price is then adjusted. So the invoice price is adjusted to reflect bricks.
So you only pay
The lower
11/12 of 1,600.
Yes.
So, in fact, the amount that's paid is not always fixed. That will depend on the subsequent bricks content of the delivery. Is that your case?
Yes, so that's how the invoicing worked, is that there would be an invoice price that was then adjusted for actual bricks. I will be corrected if I've misrecalled that, but that is how I think it was. So the invoice comes with the delivery, and at that point you know what the bricks value is, and so it's adjusted on the invoice.
How do you know what the bricks value is? How is that?
Because they sample it, I assume.
By sampling?
Yeah. So because the invoices, the delivery documents are at clause 12, and they include the commercial invoice, certificate of analysis, etc. So they'll know what the bricks is when the goods are delivered.
Thank you. And then just as one other small point I want to clear up, that the invoice price is adjustable according to bricks value plus or minus 5 bricks.
Yes.
Does that mean that if it's more than 65 bricks, you don't adjust further, and if it's less than 55 bricks, you don't adjust further? Because the quality, for example, allows down to minimum 50 bricks.
Yes, I've seen that, and I'm afraid I don't know the answer to that question. I couldn't find an example of where I don't know what they did in practice, I should say.
I'm just asking you how the
But
contract works.
In terms of...
Is that how you give effect to the plus or minus 5 bricks?
Yes, so I would say the way you give effect to it is that if it's only adjusted plus minus 5. The other way is that just means as long as you hit your quality criteria, it's then adjusted further. So it could be adjusted plus 10, minus 10. But I think the better interpretation is that you're stuck with it plus minus 5. So if it's 50, you're priced at the same place as if it was 55 bricks.
Yes. Otherwise, it's difficult to give any content to
Precisely.
minus 5 bricks.
Yeah, precisely. So if you were at 50, you would be hitting the minimum quality criteria, but you would be invoiced at the same as if it was 50 or 55.
Thank you.
Now, the bit that's so the mechanism is common ground, but the bit that's a bit controversial is the commercial rationale underpinning the use of the free trucks. So, in this contract, i.e., whether the use of the mechanism indicated that the parties intended the price to fluctuate or reflect market price fluctuations. And my learned friend does not challenge the factual finding at the end of paragraph 9 of the judgment that is how the men who negotiated the contract understood that term or understood the function of free trucks, but says that is not how the term was used in the contract. And I'll get onto that later. For the avoidance of doubt, it's not a big point for me, but I do rely on it, and I'm just flagging it now so that your lordships know what is and isn't common ground between myself and my learned friend. And in terms of the dispute at trial, there were a number of issues at trial, and that's reflected in, for example, the agreed list of issues, which is in the supplemental bundle at tab 1, and the summary issues set out in the first instance judgment at paragraph 21, as well as the summary conclusions at paragraph 145 of the judgment. And the point that's under appeal is essentially issue 1 in the judgment, namely whether the contract is an unenforceable agreement to agree, insofar as 2/3 of the 3,600 metric tons are concerned, so the 800 metric tons per year. Though there is an overlap with issue 2, what is the price? And in relation to that key question, the judge held that the contract was an unenforceable agreement to agree, insofar as that 2/3 were concerned. And I say he was wrong to do so, because this is a case where Section 8.2 of the Sale of Goods Act applies, and it's in any event plain that it's appropriate to imply a term. And I'll look at the pleading in a minute. There is then a further question about what that price in fact is in this case. And that question has not been decided by the judge. Now, my primary position is that if I succeed on this appeal, that question of what the reasonable price or the market price, depending on what this court finds, that question should then be remitted to the judge. And I flagged the possibility that this court could decide that question, but my primary position is that the trial judge should, because he heard the evidence, and because in this case it will in any event have to be remitted to him, because if I succeed, there are questions about the quantum of damages, and that's reflected at paragraphs 140 and 144 of the judgment. So those issues will have to be determined in any event. So I just very briefly wanted to take you to...
You needn't deal with this now. Speaking entirely for myself, I will be interested in you telling us what you say the figure is that he should have chosen.
Yes.
For example, December 2018 for the 2019.
Yes, and I will tell you.
And the basis upon which you say that.
And I will tell you that as well.
A reference to the evidence.
Yes, I will tell you that as well.
Thank you.
So just to briefly show you the implied term. So if one goes to tab 8, page 153.
In which bundle?
My apologies, core bundle, tab 8, page 153.
Thank you.
All right, so paragraph 15 is the Sale of Goods Act. I could have pleaded that as an implied term as well. I don't think it matters. Paragraph 13 is reasonable endeavours. Paragraph 14 is the key provision for present purposes. In the further alternative on a true construction of clause 5 or pursuant to an implied term, if the parties were unable to agree a price, the defendant would pay a reasonable price, alternatively, if different, the market price for the product at the relevant time. And as I've already said, it is the Section 8 SOGA question and the implied term that I'll be focusing on today. And the way in which the implied term is phrased is if the parties were unable to agree then a reasonable alternatively market price would be paid. And as your lordships will see shortly, when I go through the authorities, that's a pretty standard way of phrasing the implied term in these kinds of cases. Though in some cases, the courts simply say that the contract was for a sale at a fair and reasonable price. And that's because, and I will get to this properly shortly, but as explained by Lord Justice Chadwick in BJ Aviation, the question is whether the use of a term like price to be agreed is inconsistent with a conclusion that the parties intended an objective criteria, such as reasonable or fair, to apply, which in turn depends, as Lord Justice Chadwick explains in BJ Aviation, on whether the court is driven to the conclusion that in the context of the particular contract, the term price to be agreed or similar meant that the parties were free to agree or disagree about price as their own perceived interest dictates. So I don't dispute that there's this stage of fixing or agreeing. The question is whether that is inconsistent with an implied term that a reasonable price be paid in the absence of agreement. And another way of putting it would be to ask, what are the parties agreeing? So turning then to the applicable legal principles, now I appreciate that your lordships will be very familiar with many of the cases that I'm about to take you to, but I will spend some time on them in any event, if I may, and that's because while the relevant cases are common ground between myself and my learned friend, there does appear to be some disagreement between us as to what those cases in fact establish and which ones are the relevant ones here. And looking at the cases that lead up to the principles in Mamadoyle also clearly show what things like part performance are relevant to and where things like the arbitration clause sit and how relevant or not they are. So I will spend a little bit of time on that. So starting at the start, so to speak, if we go to Lord Justice Ricks's judgment in Mamadoyle, and that is at tab 14 of the authorities bundle. And I should say that the sort of summary of the principles are at paragraph 69 of this judgment and paragraphs 19 to 24 of BJ Aviation, which is Lord Chadwick's, But by way of background, as your lordships may be aware, Mamadoyle concerned a contract for the handling of crude oil. A question arose as to whether the provisions in relation to a handling fee amounted to an unenforceable agreement to agree beyond the first year of the contract. The fee was fixed for the first year, but not the next 9. And that was stated at clause 3 of the contract, which is quoted at paragraph 2 of Lord Justice Ricks's judgment, which is page 78 of the judgment, page 123 of the authorities bundle. However, the contract also provided that the agreement was to be valid for 10 years. And that was at clause 7 of the contract, also quoted at paragraph 2 of Lord Justice Ricks's judgment, also page 78 of the judgment, page 123 of the authorities bundle. And so the question was, is the contract unenforceable beyond that first year? And the court held that it was not, stating, and this is at paragraph 73 of the judgment, for your lordship's note, in my judgment, the 1993 contract should be viewed as a contract for a fixed period of at least 10 years, and a term should be implied that in the absence of agreement, reasonable fees should be determined for the period after 1994. Now, as Lord Justice Rick states at paragraph 73, subparagraph 5 of the judgment, which I will take you to shortly, the contract in Mamadoyle did not expressly state that the fee was to be agreed after the first year of the contract. But in summarizing the case law and the principles, Lord Justice Ricks takes into account cases where the contract in question did include those express words. So turning to the summary, which starts at paragraph 52, he first states rightly that each case is to be decided on its own facts. And then he starts with May and Butcher, and that's at paragraph 53 of the judgment. And there we see the well-known finding that the sale of old tentage at prices as shall be agreed from time to time and delivery periods as should similarly be agreed was in its entirety an unenforceable agreement to agree. So in May and Butcher, there was no intention to contract, no contract at all for any tense. Then at paragraph 55, Lord Justice Rick states the very next case, also in the House of Lords, went the other way. And then he summarizes the facts and decision in Hillas and Arcos. And I won't go through all of that. There is quite a lot of it. But I would like to draw your lordship's attention to the following, a couple of passages. So first at paragraph 55, we see the facts are there summarized, including at the top of page 86, column 1, two problems. So that it was clear that there was a contract for 1930, and the question was, is there a contract for 1931 as well? 22,000 standards of softwood goods of fair specification over the season 1930, with an option of entering into a contract with the sellers for the purchase of 100,000 standards for delivery during 1931. The 1930 season contract was performed and two problems arose. I'll just leave you to read that.
Yes.
And then at paragraph 57, as to the second point identified at paragraph 55, so the question of whether the contract merely contemplated a future bargain, the terms of which remain to be settled, Lord Justice Rick states, as to the second point, Lord Tomlin held the language, the option of entering into a contract, merely emphasized that there was no contract until the option had been exercised. It was not a case of a mere agreement to agree. Then at paragraph 58, Lord Justice Ricks quotes Lord Wright's judgment, stating that Lord Wright's summary expresses the point as well as it has ever been expressed. And then if I could just ask you to read the first paragraph on page 86 of the judgment, columns 2, starting the document of the 21st of May, 1930.
Do you want us to read the whole of that column?
So just the first paragraph, down to meaning of the parties can be extracted.
Thank you.
So
Yes, thank you.
yes, so what I take from it, so here Lord Wright is emphasizing that the intention to contract for both years was clear. Businessmen often express themselves in crude or summary fashion. The court should seek to interpret contracts so that they are valid rather than ineffective. And the court should not be, quote, too astute or subtle in finding defects. Next, it may be appropriate to imply terms, for instance, by reference to what is just and reasonable. And this is particularly so when the contract is one for future performance over a period, because the parties may understandably not want to fix everything at the outset, i.e. the commercial rationale is clear, and it gives prices and times of delivery and contracts for the sale of goods as, quote, obvious illustrations of where such an implied term may well be appropriate. And then over the page at 87 of the judgment, column 1, still Lord Wright, such matters may require, as the performance of the contract proceeds, some consultation and even concessions, but there is no uncertainty involved, because if there eventually emerge differences, the standard of what is reasonable can, in the last resort, be applied by the law. And then he quotes the Latin maxim, if something is capable of being made certain, it should be treated as certain. Similarly, at the bottom of page 87, column 1, final paragraph, when the learned Lord Justice speaks of essential terms not being precisely determined, i.e. by express terms of the contract, he is, I venture with respect to think, wrong in deducing as a matter of law that they must therefore be determined by a subsequent contract. He is ignoring, as it seems to me, the legal implication in contracts of what is reasonable, which runs through the whole of modern English law in relation to business contracts. And then he quotes Hoadley, what is implied by law is as strong to bind the parties as if it were under their hand. This is a contract in which the parties are silent as to price and therefore leave it to the law to ascertain what the commodity contracted for is reasonably worth. At paragraph 59, we see May and Butcher is addressed. No one would dispute such a rule, but in my judgment, the courts of appeal were not justified in thinking this House intended to lay down universal principles of construction to negative the rule that it must be in each case a question of the true construction of the particular instrument. In my judgment, the parties here did intend to enter into and did enter into a complete and binding agreement, not dependent on any future agreement for its validity. So Lord Wright is emphasizing that just because a contract uses words like price to be agreed, that does not mean that the contract will necessarily be too uncertain to be enforced. May and Butcher was not laying down any universal principles of construction. And then he states that in any event, the contract in Hillas did not expressly say that prices or times were to be agreed. But as I've said, the wording in Hillas was phrased in terms of an option, which in my submission is very similar. So Lord Wright was simply not persuaded that the use of that sort of language meant that there was an unenforceable agreement to agree in relation to the part of the contract before him, when the intention to contract was clear in relation to the whole contract, and because the contract was for future performance over a period of time, such that the commercial rationale for not fixing everything at the start was also clear. And we will see that he was not alone in that conclusion. The next case Lord Justice Ricks looks at is Foley and Classique Coaches, and that is at paragraphs 61 to 62 of the judgment. And the importance of this case is that it is a case where the contract in question did include the phrase, a price to be agreed, but that did not render the contract unenforceable as an agreement to agree. And at paragraph 61 of Mamadoyle, there is a summary of the case. The sellers sold the buyers a piece of land to use the latter's business as coach proprietors, and also contracted with them to supply all petrol required for that business at a price to be agreed by the parties in writing and from time to time. There was an arbitration clause. The Court of Appeal said that a term was to be implied that in default of agreement, the price of the petrol was to be a reasonable price. If that could not be agreed, it could be settled by arbitration. The fact that the contract had operated in the past and was part of an overall transaction, as well as the utility of the arbitration clause, were all factors in the court's decision. And then they said it might have been said that the critical factor on the reasoning of May and Butcher was that the language of to be agreed had been used, thus ousting the possibility of implying a term for a reasonable price, but that was not the result. As Lord Justice Scrutton said, and again, in Hillas and Arcos, the House of Lords said that they had not laid down any universal principles of construction in May and Butcher. And then we see Lord Justice Maugham, I desire to say first that it is plain from the surrounding circumstances that the agreement as to the sale and purchase of the petrol was intended to be a binding contract, and it formed part of the inducement for the sale of the land. Secondly, the agreement was duly stamped and bears all the signs of a legal contract, unlike in May and Butcher. And so here again, the Court of Appeal emphasizes that just because a contract contains words like price to be agreed, that alone does not mean that the contract is unenforceable as an agreement to agree, and that one has to look at whether, despite those words, there is an intention to contract in relation to the items for which price is to be agreed. And in Foley, the intention to contract is established by past performance and looking at the document itself, which looked like a proper contract.
And the arbitration clause.
I will get, and the arbitration clause was a way in which, I think the relevance of the arbitration clause was that the relevance of the arbitration clause is either that it indicates that a sort of objective criteria is to be used, or it gives a mechanism for identifying the reasonable price as a third-party valuer would, for example. But as I'll show you, the third-party valuer cases can cut both ways. And I'm sure, though this, so in Foley, the intention to contract is established by the past performance and the other things. And though I'm sure this goes without saying, whether the contract has been part performed is not directly relevant to whether a term can be implied, certainly if that performance is after the contract, because post-contractual conduct is not relevant to that. But performance can be relevant to whether there is an intention to contract, and that is then relevant to whether it is appropriate to imply a term as to reasonable price. But as I will show your lordships, that intention to contract in relation to the all and not just part of the contract can also be found in the terms of the contract itself, and that was in fact the case in Mamadoyle, and I say is the case here. And the need or relevance of looking at whether there is an intention to contract is that if there is, but no price is specified, then in many cases the parties will be taken to have agreed a reasonable price, because if they intend to contract, but do not specify a price, a reasonable price is the most likely inference. And that can be the case even in the face of language that price will be agreed, as was the case in Foley. So turning back to Lord Justice Ricks in Mamadoyle, Lord Justice Ricks then goes on, and I'm now at paragraph 62.
Sorry to hold you up.
Yes.
But we're not going to go, for reasons I entirely understand, back to the cases themselves. But in May and Butcher, am I right in saying it was said in pretty unequivocal terms that so far as Section 8 was concerned, if there were an agreement to agree a price, then it didn't fall within Section 8.
Well, I take umbrage with. I don't agree with that.
I
I take issue with that. I
you
apologise.
could take umbrage with the lordship's 90 years on.
I apologise.
Not with the law.
I don't agree with that. I think May and Butcher was simply saying that on the construction of that contract, the implication is ousted.
I think we ought to look at it.
Well,
We will. We will be looking at it. If I may look at it, I don't mean to.
Do
push
come
back,
back to it if you
But
like.
I'm going to go through the Section 8 argument separately.
All right.
I'm not ignoring it. If that.
All right. I just wanted, whilst I'm just clearing my mind on this, to see that certainly the way in which Lord Justice Ricks has identified the important points in the cases, when it comes to Hillis and Arcos and Foley and Classic coaches, they certainly treat the fact that there is an agreement to agree as something which is not inconsistent with whether it's a matter of construction or implying a term, can treat the contract as being an agreement at a reasonable price for a reasonable amount or whatever it may
Yes.
be. I entirely understand that.
Yeah.
I don't read any of the passages we've so far been shown in those cases as undermining what was said in May and Butcher, if it was what was said.
Yes.
That if you've got a specific agreement that the parties shall agree at a subsequent price, that doesn't involve the contract being silent about it so as to
Yes.
give rise to the Section 8.2 term.
And I think
And if you want to come back to that too, I just wanted to flag that.
Yes.
that question is very much
At this
one that I
Right.
understand I need to address. And I think Lord Justice Chadwick sort of answers that question, but we'll get to
Come on to that.
Yes.
Now, are you going to take us, after Foley, we get on to a series of other cases, starting with Scammell and Nephew. Are you going to take us through any of those?
Yes, so I was going to, so the bit I wanted to take you through in Scammell is Viscount Mons' quote where he said, so Scammell, is that?
62 of Mummy Doyle.
Thank you, my lord. So he says, Viscount Mons' judgment where he refers to the need for a, quote, reasonable degree of certainty. So that's the first point, reasonable degree of certainty. And then he goes on to say, this general rule, however, applies somewhat differently in different cases. In commercial documents connected with dealings in a trade with which the parties are perfectly familiar, the court is very willing, if satisfied that the parties thought they made a binding contract, to imply terms in particular terms as to the method of carrying out the contract. And then he refers to Hillis and Arcos.
Yeah.
So here Viscount Mons is emphasizing that in the context of a commercial contract connected with dealings in a particular trade, it is more rather than less likely that an implied term is appropriate. And that is, of course, because the parties to that type of contract will be aware of how price or notice, etc., is usually set in the particular trade. And then the next case I wanted to take you to, or draw your attention to, is F&G Sykes and Fine Fair.
Yes.
And that's summarised at paragraph 64 of Lord Justice Ricks's judgment in Mamadoyle.
The chickens.
It's the chickens, exactly, the chicks. And as summarised there at paragraph 64, that this was a case where chicken breeders entered into a 5-year agreement with a supermarket chain to provide a stipulated number of chicks in the first year, and thereafter such other figures as may be agreed. So again, that may be agreed language appeared in the contract in F&G Sykes. And nevertheless, the court did not find the contract was unenforceable as an agreement to agree, but instead found, and this is quoted at paragraph 64 of Mamadoyle, in a commercial agreement, the further the parties have gone with their contract, the more ready the courts are to imply any reasonable term so as to give effect to their intentions. But and then I'll leave you to read that section. When nothing has been done, it is easier to say that there is no agreement. But when an agreement has been acted on by the parties, as here, and the parties have been put to great expense in implementing it, we ought to imply a reasonable term. You can either imply a term that in default of agreement, the number shall be a reasonable number, with a subsequent provision that in case of any dispute as to what is reasonable, it should be determined by arbitration, or alternatively, you can run those two terms together. And there's a further passage in Lord Denning's judgment just after that passage, and I will just quickly take you to that.
Tab 8.
Tab 8, page 52. So it's the 1, 2, 3, third paragraph. Any other view would be completely contrary to the intentions of the parties. The agreement was to last for 5 years, and then afterwards from year to year with 4 years. I think that's 4 months. That should be 4 months' notice. The contention of fine fare would be to reduce it from a 5-year agreement to 1 year. I may add that if fine fare had succeeded in putting up their factory, they would have been the first people to complain if Sykes had said this does not last for more than 1 year. And the reference to the factory is explained at page 57 of the judgment to third paragraph down. So when they entered into the contract with Sykes, fine fare thought they were going to build a factory which they were going to use for processing the chicks. And then they didn't build the factory for various reasons. They no longer needed the chicks, and then said the agreement was an unenforceable agreement to agree from after the first year. And just to flag, the facts of Sykes are not that different from the facts of this case, in the sense that a long-term contract was agreed, and then one party decided it didn't want the contract after all, having entered into it. And we see that the respondent, having entered into the contract, no longer wanted the 3,600 metric tons at paragraphs 33 and 36 of the judgment. And I won't turn you to them, but there was essentially a dollar contract that they were going to use this product for. They lost the contract. They didn't want to deal with the appellant anymore, etc. But turning back to the law, the points that come out of F&G Sykes is that, again, the long-term nature of the contract is being emphasized, as was the fact that there was an plain intention to contract for the 5 years, not just the 1 year. And in establishing that, the court looked at the fact that the contract stated that it was for 5 years and the fact that it had been acted upon. And there is also a reference to the arbitration agreement, and I will address that in a bit more detail by reference to some other authority. But in my submission, the respondents place far too much emphasis on the arbitration agreement. So back to Lord Justice Ricks in Mamadoyle. We're now at Sudbrook, which is paragraph 65 and 66 of the judgment in Mamadoyle. And I will leave your lordships to read those paragraphs in your own time.
Right.
It's relevant in the context of Gillett and Skye, which is one of the cases relied on by my learned friend, albeit to a much lesser extent than at trial. Now, in summary, both Sudbrook and Gillett and Skye are cases where the price was to be determined by a third-party valuer. And essentially in Sudbrook, that led the House of Lords to conclude that the price was to be determined, that the fact that the price was to be determined by a valuer supported the conclusion that the contract was for the sale at a fair and reasonable price. And you see that at the bottom of page 88, paragraph 65. By contrast, in Gillett and Skye, the court decided that on the terms of that particular contract, the fact that the valuer was to determine the price, so the agreed mechanism itself, was mandatory. And this precluded the implication of a term for a sale at a fair and reasonable price.
Sudbrook was actually the price agreed upon by two valuers, which necessarily contemplates the possibility of not agreeing, doesn't it?
Well, but in Sudbrook, the House of Lords held that the contracts were for a sale at a fair and reasonable price.
No, indeed, but the facts were different. It was the mechanism was an agreement between two valuers.
Yes, I'm simply pointing out that in Gillett and Skye and in Sudbrook, the fact of a valuer being involved, it can kind of cut both ways, depending perhaps on precisely how it is drafted. And if my recollection serves, in Gillett and Skye, one of the points relied on by the judge is where reasonable comes in the phrase. So reasonably agreed rather than agreed a reasonable, we can look at that in due course. But the judge looked very carefully at the precise language in the contract in Gillett and Skye and where the word reasonable kind of comes. And the relevant references are at paragraph 60 of my skeleton argument. And then the other thing in Gillett and Skye, paragraph 67 of Mamadoyle, you see there Lord Justice Ricks is addressing the relevance of the arbitration clause, and he ends up by saying, which is not to say that the court will not itself provide the dispute resolution machinery, even in the absence of an arbitration clause, i.e. the arbitration clause is by no means crucial. Finally, paragraph 68, Lord Justice Ricks considers G. Percy Trentham. The Court of Appeal was there considering whether certain contracts had ever been concluded. And here we see the point is being made about the relevance of performance, no doubt more eloquently than I have made it. The fact that the transaction was performed on both sides will often make it unrealistic to argue that there was no intention to enter into legal relations. It will often make it difficult to submit that the contract is void for vagueness or uncertainty. So that's the relevance of performance. It may evidence an intention to contract, which in some cases can of course be evident from the contract itself, as was the case in Mamadoyle, and I'll take you to those paragraphs shortly, and as I say is the case here. So then we get to paragraph 69, and I'm sorry I'm going at quite a speed because there's a lot to go through, but paragraph 69 of Mamadoyle, and here we see Lord Justice Ricks summarises the principles he takes from the authorities. And they are not numbered, though many people have numbered them before, and I've numbered them 1 to 10. And I won't read them out, but the important ones for present purposes are Lord Justice Ricks states among the principles that where no contract exists, the use of an expression such as to be agreed in relation to an essential term is likely to prevent any contract coming into existence, because one cannot agree to agree. So where there's no contract in relation to anything. However, where a contract has once come into existence, even the expression to be agreed in relation to future executor obligations is not necessarily fatal to its continued existence. That is particularly the case in contracts for future performance and long-term contracts where the parties may desire or need to leave matters to be adjusted in the working out of the contract. And he also says that an expressed stipulation for a reasonable or fair measure will be sufficient criterion for the courts to act on. But even in the absence of express language, the courts are prepared to imply an obligation in terms of what is reasonable, and that those implications are reflected in but not exhausted by the Sale of Goods Act, Section 8 and Section 15 of the Supply of Goods and Services Act. And now, just to draw...
And 10 on the arbitration clause?
The presence of the arbitration clause may assist the courts to hold a contract to be of sufficient certainty. I don't deny that the arbitration clause can assist. Perhaps I can deal with that now. So Beer and Bowden, if we can turn up Beer and Bowden, that's at tab 11. And that's, Beer and Bowden is a case where a lease was granted at a fixed rent for the first 5 years of a 14-year term, and thereafter at a rent to be agreed. And it was implied that in the absence of agreement, the rent would be the fair rent, excluding the value of tenants' improvements. And there we see Lord Justice Gough delivers the main judgment, and he comments on the arbitration clause at page 526 of the judgment A to F. And I won't read it all out loud, but I just highlight between B and C. So someone had argued that the ratio of Foley was that you needed to have the arbitration clause. But I do not think that is the true ratio of the clause. Where you have got an arbitration clause, then if you imply a term that there shall be a reasonable price or a fair rent, any dispute as to what reasonable or fair falls within the arbitration clause. And if you have not got one, it falls to be resolved by the court. But in my judgment, the presence or absence of an arbitration clause does not matter. And then over the page, 527E, again about the arbitration clause. At all events, in my judgment, such a clause is not essential. And then for your lordship's note, and I'll show you that's how Mamadoyle deals with the arbitration clause and its reasoning as well. And it's also how the arbitration clause is analysed in, for example, TK Tankers, which is a case my learned friend relies on. And that's at paragraph 186 of the judgment, which can be found at tab 20, page 298, where the judge says, well, if there had been an arbitration clause, that would have been another string to the bow, but it's not essential. All right, so going back to Lord Justice Ricks, and I just wanted to point out a few things about the reasoning in that judgment. Now, each case is different and is decided on its own facts. But the reasoning is at paragraph 70 to 75, and it's all summarized at paragraph 73. And there are 9 subpoints made at paragraph 73.
Yes.
And so points 1 and 4 all go to the fact that in Mamadou the contract expressly stipulated that it was a contract for the full 10 years. So it all goes to the contractual intent. And that was plainly important because it showed the parties' intention was to be contractually bound for the full 10 years. At subparagraph 4, that leads Lord Justice Ricks to the conclusion that if the effect of clause 3 is to cut down the contract to a period ending in 1994, this cannot be so as a matter of construction, but because the agreement is incomplete or uncertain beyond that period. The authorities suggest, however, that at any rate in principle, there is no difficulty in implying a term that the fee should be a reasonable one. At subparagraph 5, Lord Justice Ricks notes that the contract does not contain the wording to be agreed, and goes on to say that therefore Mamadou is not a case where there's a question about whether that kind of wording prevents the implication of a reasonable price. And then at paragraph 6, Lord Justice Ricks makes 2 points. First, he says that there is no evidence that the resolution of a reasonable fee would cause any difficulty, pointing out that previously when difficulty arose, it was because of something quite extraneous. So there had been some difficulty, just not relevant difficulty. And then he says this: although it is true to say that the contract itself contained no mechanism or guidance, other than the arbitration clause, as to how a reasonable fee would be derived, I do not consider that the contract should fail on that ground. Contractually derived criteria or guidance may be of assistance in finding an implied term for a reasonable price, but the authorities indicate that the courts are well prepared to make the implication even in their absence. In other words, contractually derived criteria can be helpful, but are not necessary or essential. And then at subparagraph 8, Lord Justice Ricks refers to the arbitration agreement. And in my submission, it's clear from that paragraph that it's not an important consideration. And he even records that Mr. Howard, who argued the case for the claimant, did not rely on it as a particularly strong point, even though there was an arbitration clause. And I say he was right not to. And as I say, that's how it was also analysed by Lord Justice Gough in Beer and Bowden and in TK Tankers. And taking a step back, save for the point about there not being the to be agreed wording or similar in the arbitration agreement, there are obvious parallels with the case presently before the court. And I will look at those parallels in a minute. But before that, I will briefly look at BJ Aviation in the Section 8 question. So BJ Aviation is at paragraph 15. And the clause in that agreement the agreement was concerned with the operation of an airport. And the contract gave an option to renew, quote, subject to the renegotiation of the rent payable. That was the clause there. And the Court of Appeal held that this constituted an agreement to agree and was consequently unenforceable. The language and structure of the relevant clause treated the renegotiation of the rent as a precondition to the obligation to grant a fresh agreement. And the clause, just for your notes, can be found at paragraph 4 of the judgment, and it expressly refers to the further agreement being subject to the renegotiation of the rent. But in my submission, the interesting point from BJ Aviation is not the facts, which are very different from the facts of this case, but the summary of the principles set out by Lord Justice Chadwick at paragraphs 18 to 24. And they start at page 142 of the authorities bundle. And he essentially says each case is to be decided on its own facts and then refers to Lord Justice Ricks and Mamadou. But the key passages for present purposes are 21 to 23, because here Lord Justice Chadwick goes on into some more detail as to how to analyse a case where there is some wording to the effect of price to be agreed or similar. And looking at those paragraphs, 21 and 23 are the key ones. 21. Second.
Would you like us to read these?
Yes, perhaps read 21 and 23.
Thank you.
So here he's talking in particular at paragraph 23 about a case where you've got the price to be agreed wording. And in order to achieve that result, the court may feel able to imply a term in the original bargain that the price or rent or other matter to be agreed shall be a fair price or market price, etc. In a contract for the sale of goods, such a term may be implied by the Section 8 of the Sale of Goods Act. So he's got in mind Section 8 of the Sale of Goods Act there. And then he says, but the court cannot imply a term which is inconsistent with what the parties have actually agreed. So if on a true construction of the words which they have used, the court is driven to the conclusion that they must be taken to have intended the matter should be left to their future agreement on the basis that either is to remain free to agree or disagree about that matter, as his own perceived interest dictates, there is no place for an implied term that in the absence of agreement, the matter shall be determined by some objective criteria. So that's the question, and I say that's the question within the context of the Sale of Goods Act as well.
Is that what Lord Justice Chadwick is saying?
Yes, I think, well, about the Sale of Goods Act, I think he's envisaging a situation where the term would be implied by Section 8 of the Sale of Goods Act. So he's envisaging a situation where there's a term among the scenarios he's envisaging is a situation where the term is implied by the Sale of Goods Act.
Was he simply saying it may be implied by Section 8, it may be implied outside Section 8, but
either way,
outside Section 8, it can't be implied if it's inconsistent with the other terms of the contract.
I think respectfully, I don't think one can say that he's saying outside of Section 8. That in only outside of Section 8 do you ask that question. I don't think that I think he's saying there are ways in order to achieve that result, the court may feel able to imply a term in the original bargain. And then he's saying there are different scenarios in which you might be able to imply that. One of them is the Sale of Goods Act, but the court can never imply a term which is inconsistent with what the parties have actually agreed. So regardless of where that implication comes from, you cannot have the implication if it is inconsistent with what the parties have agreed. So I think in his analysis, he is envisaging a situation where the implication comes from the Sale of Goods Act, and he's saying, nevertheless, you have to ask this question.
Another crucial words there, on the basis that either is to remain free to agree to disagree about the matter.
Yes, and so I mean, perhaps we should look at May and Butcher first, and then, or I could tell you, perhaps let's do it this way. So, and I was also going to take you to Barton and Morris, but if the contract provides for a price to be agreed, then in the context where the parties, the question is whether the parties are free to agree or disagree as their own perceived interest dictates. Because if they are not, the contract is silent as to a situation where they have not reached agreement. And if that's the case, then the Section 8.2 implication is not inconsistent with the express terms of the contract. If the parties can agree or disagree as their own perceived interest dictates, then the contract envisages that there may be no agreement at all. And an implied term for a reasonable price would be inconsistent with that, and the contract is then not silent about what happens if no agreement is reached. It envisages that there may then be no sale at all. So that's how I understand it.
What's the relationship between that question, that, as Lord Justice Chadwick put it, they must have intended to be left to their future agreement on the basis that either is to remain free to agree or disagree,
Yeah.
and what Lord Wright said about May and Butcher, where he said the question is whether the parties did intend to enter into and did enter into a complete and binding agreement, not dependent on any future agreement for its validity.
So I think that's related to the way I put it earlier, which is what are the parties agreeing? So are they free to say, well, I know I agreed to buy 10 chickens, but I actually only need 1 chicken, so I'm now going to pay you for not the market price for the chicken, but I'll just pay you for 1 chicken, right? And what Lord Wright is saying, well, if they've already firmly agreed to buy 10 chickens and there is a market price for chickens, then the fact that they didn't identify a price, the natural conclusion is that they were going to pay the market price. And that implication is reflected in Section 8.2 of the Sale of Goods Act, essentially.
I mean, a simpler way of looking at it may simply be that Section 8 provides for certain circumstances in which there is to be an implied term to pay a reasonable price. That's where the contract is silent, and May and Butcher stands for a proposition that if the parties have agreed to agree on a fixed price, the contract isn't silent about it. But Section 8 doesn't exhaust all of the circumstances in which you can imply a term, and you can imply a term outside Section 8, provided that, as Lord Justice Chadwick says in paragraph 23, that the contract on its true construction doesn't drive you to the conclusion that that would be inconsistent with what they've agreed. So
that was my alternative way of reading Section 8, which is if you look at Section 8, which is at tab 2, which is that you never get to Section 8.2, because an implied term is just as much part of the contract as an express term. So the price in a contract of sale may be fixed by the contract or may be left to be fixed, blah, blah, blah. If there's an implied term saying that in the absence of agreement there's a reasonable price, then there is a price, then you...
It's fixed by the contract.
Yeah, it's fixed by the contract. So you end at Section 8.1.
Exactly.
But then I would still say that the Section 8.2 is still relevant because it shows that in sale of goods cases, the natural inference is for a reasonable price. So that assists me in implying the reasonable price.
Perhaps put it another way, if the contract is completely silent, then it's reasonable price. If the contract, by implication, agrees on a reasonable price, well then that supports the reasoning that it ought to be a reasonable price.
Yes. So
there's a bit of chicken and egg about it.
There's a bit of chicken and egg about all of it, because I think that if one looks at, there's nothing obviously in the authorities or the Sale of Goods Act itself that suggests that it's harder to imply, the idea here was to make it harder to imply a term for reasonable price in the context of the Sale of Goods Act rather than easier. So whichever way you analyze it, it is the case in my submission in the context of sale of goods. It is that the natural inference is a reasonable price unless the contract says something different. All right, let me just find my place.
So have we dealt with all you want to extract from BJ Aviation?
Yes, that's all I want to distract from BJ Aviation. I was going to take you to May and Butcher very briefly. So the passage that my learned friend relies on in May and Butcher is tab 7 of the authorities bundle, page 46. And it's that second line.
Sorry, which page are we on?
Apologies, tab 7, page 46 of the bundle, page 22 of the authority, second line.
Second line on 46.
So page 46 of the authorities bundle, there's a line at the top on the right and a line at the bottom. If the parties fail to arrive at an agreement. So sorry, tab 7, page 46 of the authorities bundle. It confusingly says Foley and Classic coaches, but.
You're right. Yes.
Second line, if the parties fail to arrive at an agreement, and then to which they have signed.
Yep.
And the bits that I wanted to highlight is, in my submission, they're not, May and Butcher is not saying that in every case where a contract says price to be agreed, the application of Section 8 is excluded or precluded. What they're saying is that the facts precluded the application of any such principle, and to do that would be to contradict the express terms of the document which they have signed. So it's a similar approach as the one taken by Lord Justice Chadwick in BJ Aviation. The question is whether the use of the words to be agreed or similar would be inconsistent with the Section 8.2 implication. And you actually see a similar analysis in Barton and Morris in the context of Section 15, albeit not in the context of an agreement to agree case. I'm conscious of time.
But we also need to bear in mind what Viscount Dunedin said on page 45, don't we? At the 3/4 of the way down, the last bit of the sideline passage, where he's dealing with the Sale of Goods Act. The simple answer in this case is that the Sale of Goods Act provides for silence on the point, and here there's no silence because of the provision that the two parties are to agree.
But there's still silence about if they're not entitled to agree or disagree as they see fit, i.e. their agreement or disagreement is some way constrained by concept of reasonableness, for example, then the contract is silent about what happens if they don't agree. So there's...
Well, I understand how you put it, but that doesn't seem to be in a question that's gone into here. They seem to have dismissed the Sale of Goods Act point on the simple basis that it's not silence if you've got an agreement to agree.
Yes, well, then they haven't addressed the point. And Lord Justice Chadwick, in my submission, has addressed the point. And in that passage at paragraph 23 of his judgment, I think he is envisaging the implication coming from the Sale of Goods Act before he asks.
I understand your point on that.
But ultimately, I don't think it matters, because if the Lord Justice Chadwick question is asked anyway, so either I'm in Section 8.1 or I'm in Section 8.2 of the Sale of Goods Act. And then the only question would be, is it harder for me to imply a term under Section 8.1 than Section 8.2 of the Sale of Goods Act? And I say it isn't, because Section 8.2 in any event establishes that it is usual in a Sale of Goods Act case to imply a reasonable price. So perhaps I don't need to look at Barton and Morris, but in that case, I'll just very briefly say that in that case, it wasn't an agreement to agree case, but the case concerned an oral agreement between an individual B and a company that owned a property to the effect that if the property was sold for 6.5 million to a buyer who B had introduced, the company would pay B a fee of 1.2 million. And the property was sold to a buyer who B had introduced, but for less than 6.5 million. And the question was, can B get a fee? And before the Supreme Court, one of the things relied on was Section 15 of the Supply of Goods and Services Act. And the majority found that the Supply of Goods and Services Act implication was not available. And that is at paragraph 41 of Lady Rose's judgment. And that's tab 22. And almost at the end, so you see they refer to Section 15.
Which
and then,
page, sorry?
Apologies, tab 22, page 382 of the authorities bundle. and they refer to Section 15 of the Supply of Goods and Services Act. And then slightly further down, however, it seems clear that this section does not apply here since the consideration for the introduction was determined by the contract. So the introduction generally, not just when the property is sold for 6.5 million. And then you see Lord Leggett.
Who is dissenting?
Yes, Lord Leggett and Lord Boroughs dissent, but they dissent on that question of whether, on a true construction of the contract, it covers just the introduction generally or just the introduction in the event that this property is sold for 6.5 million. And we see Lord Leggett's analysis is at 143, 161 to 177. And I won't be able to take you through all of that, but just to give you the references, and then negativing the implied obligation. And 162 in particular, in circumstances not governed by an express term as to remuneration, the consideration is not determined by the contract, therefore remains subject to the implied term. So he's basically saying, you know, just because they've provided for a fee in the event that the property is sold for 6.5 million doesn't mean they were also saying that there would be no fee if the property was sold for less than 6.5 million. And he's therefore engaging with the question of whether the provisions of the contract are inconsistent with the Section 15 implication, which is similar to Lord Justice Chadwick's wording in BJ Aviation. And we even see him quote using very similar language at paragraph 165. He's quoting from Firth and High Lane. Lord Justice Sellers likewise saw in the express terms nothing inconsistent with an implied contract or term to pay a reasonable remuneration. And one sees very similar analysis in Lord Boroughs' judgment, and the relevant paragraphs are 210 to 225. And again, I won't have time to go through all of that, but for example, 221, you see the heading there, has the term as to reasonable remuneration implied by law been excluded? And then 225, the correct view is that the contract did not exclude and was consistent with the term implied by law, etc. But the point is that all of the judgments, majority and minority, are asking the same question. Do the express provisions of the contract already answer the relevant question? And the majority say yes, because the contractually agreed fee was for the introduction, i.e. the introduction generally. And the minority say no, because the contractually agreed fee was just for the cases where the property was sold for 6.5 million. And so said nothing about the situation where the property was sold for less. And that's where I get, and I say that's analogous to this situation, because the contract, unless the parties are free to agree or disagree as their own interests dictate, the contract doesn't answer the question what happens if they don't agree.
Could you just give me the paragraph numbers in Lord Leggett's
Of course.
judgment?
143, he does a little intro, and then
Yes.
161 to 177.
All right, thank you.
And then I would just add that there's obviously no yeah, well, I've already said that. I don't need to repeat myself. All right. Let me just, given timings, I'm going to jump over a few bits. So, all right. So, bearing in mind the case law that I've just taken you through,
Yes.
the questions in this case are as follows. The first question is whether there is an intention to contract for the full 3,600 metric tons. If there is, the court will strive to give effect to the bargain made and may be able to do so by reference to a reasonable or market price, for example. And in this context, as I've said, I have the benefit of Section 8.2 of the Sale of Goods Act, so the court will not have to strive very hard. But even if I can't rely on Section 8.2, I can establish an implied term for a reasonable price, and I'll explain that very shortly. The next, albeit related question, is whether such an implication is inconsistent with what the parties have actually agreed, and that's Lord Justice Chadwick in BJ Aviation. Because of the phrase open price to be fixed at clause 5, or agreed volume and price at clause 3. And in relation to that, if there is an intention to contract for the full 3,600, it is only when the court is driven to the conclusion that the parties must be taken to have intended that the matter should be left to their future agreement on the basis that they remain free to agree or disagree as their own perceived interest dictates, that there is an unenforceable agreement to agree.
Just say that again. Just say that again.
It's only when the court is driven to the conclusion that the parties must be taken to have intended that the matter should be left to their future agreement on the basis that either is to remain free to agree or disagree about that matter, here price, as his own perceived interests dictate, that there is an unenforceable agreement to agree. So when they're entitled to
That phrase, on the basis that, it was the phrase that was used by Lord Justice Chadwick.
On the basis that,
Yes.
I'll double check.
Yes. That was the phrase used.
And in the context of answering that question, it's very relevant to consider whether the contract is a long-term contract for future performance. And it's also relevant to consider whether the contract is concluded in the context where the parties are familiar with the trade in question, bearing always in mind that the court is only required to find a reasonable degree of certainty, which is Viscount Mom and Scammell, and should not be, quote, too astute or subtle in finding defects, which is Lord Wright's phrase in Hillas and Arcos.
Does the phrase on the basis that mean anything more than with the consequence that?
Let me get the phrase in front of me in full, so I'm not...
So that's back to tab 15. Okay.
On the basis that either is to remain...
That is the phrase used, I think.
It is. And I think it just means with the consequence that either is to, or with the... What he's saying is they can not agree.
Yeah, with the consequence that.
Yes, exactly.
Okay. Thank you.
Well...
It may be a sensible question to ask whether what the parties have intended in their renegotiation or negotiation of the price is that they are allowed to look to their own interests, because the consequence of that is, if they are, it will be impossible to determine what is a fair or reasonable price by objective criteria.
Quite, or they don't need to agree a fair or reasonable price. They can say, I will only buy this for below market. A buyer could say, I'm not prepared to pay the market, assume there is a market price, I'm not prepared to pay market.
Or there is no such thing as a fair and reasonable price if the parties are free to choose a price which suits their commercial interests.
Right.
The concept just doesn't exist.
Yes, well, it's sort of, again, it's
You
a bit...
can put it in several different ways.
Yes.
But it's not necessarily, one's not necessarily looking at whether that's the consequence of the construction. One may be looking anteriorly as to whether you can derive that intention from the circumstances.
From the exactly,
and the factual matrix and so on.
Yes, precisely, which is why whether there is a sort of standard way of identifying price becomes relevant.
But is that basis a crucial marker for determining whether it's an unenforceable agreement or simply a factor, a consequence?
I think.
Are we looking to see in all the circumstances whether that is the effect of this? So it's a marker for its unenforceability.
Well, if you take a simple example where the contract says the parties agree a price but can
walk
disagree,
away.
Yeah, then that's obviously an unenforceable agreement to agree. And the question is, looking at the surrounding circumstances, is that what the contract is saying by using a phrase like price to be agreed? Or is it consistent with an implied term that they will agree a reasonable price if they don't agree?
Right. Sorry,
And
I took you out of your stride.
Well, the long term, that's why the long-term nature of the contract is important, and the trade context. Because if you've got a firm commitment to buy over 3 years, for example, and you haven't identified the price for years 2 and 3, but you have firmly agreed to buy in years 2 and 3, and there is a standard way of identifying market price, for example, then the natural inference or standard approach to it, then the natural inference, because you have expressed an intention to contract for the full 3 years, is that by not identifying a specific price, you were essentially agreeing to agree a reasonable price or the market price. That's why Lord Justice Ricks places so much emphasis on that first question. Did you agree to be contractually bound for the full period of the full contract or only for part of it? And why on the facts of BJ Aviation, the fact that it's phrased as a kind of condition precedent, the agreement is a condition precedent to any contractual intention coming into play, is relevant.
Yes.
So
you've set out what the questions are.
Yes. Well, on the facts of this case, my position is that despite the use of the phrase open price to be fixed at clause 5, or the phrase agreed volume at clause 3, an implied term that in the absence of agreement a reasonable price is to be paid is not inconsistent with what the parties have actually agreed. And I have 5 reasons for that. First, this is plainly a case where there is a contractual intention in relation to the full 3,600 metric tons. The contract clearly and unequivocally states that the quantity is 3,600 metric tons, could be a bit more, will be a bit more. The judge rightly accepted that the contract evinced an intention to deal with the full quantity, so not just the 400 metric tons, but also the 800 metric tons, and that 800 is not an optional or target amount. And that's in particular at paragraph 79 to 83 and 112 of the judgment, in particular 82. And in my submission, this case is therefore immediately distinguishable from May and Butcher for that reason alone. This is therefore a case where, as the judge rightly accepted, the court must strive to give effect to the parties' bargain. And that's at judgment paragraph 79. So that's my first point. Contractual intention in relation to the whole thing, not just the 400 metric tons. Second, this case, like Hillas, Mamadoyle, F&G Sykes, Beer and Bowden, and Queensland Electricity Generating Board, which I haven't taken you to but is referred to in my skeleton argument, relates to a long-term contract with future performance over a period of time where the parties may understandably desire or need to leave matters to be adjusted in the working out of the contract, which is the phrase Lord Justice Ricks uses. I think it might actually be Lord Wright's phrase. As I've said in my skeleton argument at paragraph 45, the commercial purpose in a long-term contract for the sale of goods of a provision that allows the price to be modified is clear. It allows the price to reflect movements in the market. The commercial purpose is inherent in a long-term contract such as this one, when there is an intention to sell the full amount, and that is particularly understandable when the price of the thing sold is linked to the price of a traded commodity with a fluctuating market price, here FCOJ. Yeah. This is in any event clear when one looks at the contractual history between the parties. So this is summarized in the judgment at paragraphs 14 to 18. So tab 6, page 83. There were 3 contracts.
Yes.
So first you've got 2017 contract, small amount, 200 metric tons, fixed price. Then you've got second 2017 contract, where you've got 3 tranches, 100 metric tons, 400 metric tons, and 500 metric tons. And that's at paragraph 16. And then you see at 17, so first you see the price is fixed for the first ones and not for the second 2. And then at 17, you see that the second 2 are to be delivered later. So that's in line with what Lord Justice Ricks was talking about. So where you've got an F&G Sykes, where you've got a long-term contract, you may well not want to fix the price at the start because the price may fluctuate. And incidentally, in relation to this, I say my learned friend is wrong to say at paragraph 21 of his skeleton argument that the court can strive less if it is only finding part of the contract to be unenforceable. The same could have been said in any of Hillas, F&G Sykes, Beer and Bowden, and Queensland Electricity Generating Board. To the contrary, it's precisely in these long-term contracts where performance extends over a period to agree that phrases like "to be agreed" will likely not be fatal, as long as there is an intention to contract in relation to the whole period of time or the whole volume or amount in question, basically the whole contract. Because otherwise, in this case, for example, the court would be cutting down a contract for 3,600 metric tons plus a bit to a contract for 1,200 metric tons, i.e. a third of the contracted for volume.
Do you say the terms of the second 2017 contract were substantially and in all material respects the same as the contract in dispute, or were they different?
I say there may be some argument between the two. I would say they have the same effect, and they both evidence an intention that the sort of later deliveries are to float.
So this establishes a commercial practice between the parties.
Well, I think it's just consistent with an intention, the commercial intention in any event inherent in these kinds of cases where there's a long-term contract.
Yes. What happened in respect to the second 2017 contract?
They were performed.
So the prices were agreed.
Yes, but I won't be able to tell you exactly what prices were agreed. No. And I don't think there was actually any expert evidence about what the market prices were at that time.
So there was no evidence for the judge about how they'd been agreed?
I think there was some correspondence evidence about that if I remember correctly, but certainly not about the market prices at those times.
So what do you draw particularly then from what you said was the commercial history between the parties that assists your case?
Well, so for example, Lord Justice Rick says in Mamadoyle, he says there's no evidence of there ever having been any difficulty in Mamadoyle, apart from sort of extraneous commercial reasons. And similarly here, what we see is where they leave prices open, they then fix the price. So there's no suggestion that it's really, really difficult to identify the price. I think that's the only thing I take. But the third point I make is this is a case where, and I'm here mirroring the language of Viscount Mom in Scammell, which is quoted by Lord Justice Ricks in Mamadoyle, the contract in question is a commercial document connected with dealings in a trade with which the parties are perfectly familiar. And furthermore, that there is a standard approach to calculating the price. And in that context, it is noteworthy that both parties were very familiar with the market in FCOJ. And one can see that
you say the evidence established that there was a standard method for calculating the price.
Standard approach
to
calculating the price for wesos. So the parties, both parties are very familiar with the market. And that I can establish by reference to the common ground in the list of issues at paragraphs 2 to 4. And that's in the supplementary bundle. So they're both very well versed in this market. So the claimant's a company engaged in the business of supplying fruit juices and associated products. The defendant is and was at all material times the largest orange juice producer in the world. Both parties contracted with these markets as suppliers and purchasers and buyers. So they both know this market very well. The parties' experts agreed that there was a correlation between the price of wesos and the price for FCOJ, with wesos being around 70% of the market price.
Well, one of them said 60 to 85% and the other said 50 to 70%. They said there's a rough correlation.
Well, they said...
Didn't they? I've taken that from the joint memorandum, but I think it does reflect what's in their report.
Well, certainly when I cross-examined, I can show you, when I cross-examined first of all, it's fair to say that Mr. Appa was the more experienced man.
Yes.
And that's recorded in the judgment. So,
yes.
Apologies, my bundle has decided to disintegrate. Let me fix it. So in terms of what the range was, I put to Mr. Appa that it would be very unusual to pay less than 70. Let me show you that. And I'll actually show you a few other things. So while I'm here, why don't I just take you through a couple of parts of this cross just to, so if we turn up tab 14 of the supplementary bundle, because this also goes to the ranges. So tab 14, page 177. And this is day 3, page 10. And if it is possible, it might not be possible. Actually, apologies. Let me first show you the actual, so Mr. Appa's report. So this is at tab 4, page 51 to 52 of the supplementary bundle. So summary of average FCOJ market prices. And the way he gets to these prices,
So pages
51 to 52 of the supplementary bundle. So he takes this publicly published information for FOB Santos, FCA Europe, CFR Rotterdam. And those are, of course, different Incoterms. So free on board, free carrier, and cost and freight. And then you see over the page at page 52, pulp wash. And then over the page at 53, he then adjusts it for bricks. So at the bottom, you then see, for example, December 2018, US dollar 1340.1551. Yes? So just, and then those are converted into euro in his supplemental report, which is at tab 6 page 75. So if we stay with December 2018, you get the euro 1180 to 1365 range.
Yeah.
All right, so bearing that in mind.
And that range just reflects the different sources.
Exactly. So
But it is all on a 70% basis.
yeah. So if one looks now at tab 14, page 177.
Yeah.
Your cross-examination.
Yes, and this is, if we look first at page 10, and perhaps if you just read pages 10 and 11, actually down to page 12, line 6. So this is relevant for two reasons. One, it explains the range. So the range just reflects the different Incoterms. And he said X works is similar to FCA, so middle of the range. And then secondly, it's relevant to the alleged uncertainties at paragraph.
So sorry. You went too fast. X works is the same as FCA, so middle of the range. I didn't follow that.
Yes, so if one.
Spell that out for me.
So if we go back to his report, so there are actually two ways one can read this, but you get page 52, FOB, FCA, CFR, and then FOB, CFA, CFR. It says CFA, I think it's meant to say FCA there, the bottom table. And then you get the market price for pulp wash. So what I was putting to him was the fact that there's a range just reflects the different Incoterms. And out of the Incoterms that he has used, the closest comparator is FCA Europe, which if you look at how the price is, unsurprisingly, CFR is the highest price because the seller does the most, and then FOB is the lowest price. So it's either the middle of the range, or if you look at the table at 45 for December 2018, you see there's actually no data available for FOB. Yes?
Yes.
And then if you look at 1341 US dollars and 1551, and then turn the page to the second table at page 53, it's 1340, 1551. So it's the same range there. So it's CFA and CFR, or FCA and CFR rather, is 1340.
CFA is
I think he just means
FCA.
FCA. I think it's just a typo, yeah.
FCA is 1341.
1341, which
and CFR Rotterdam is 1551.
yes. So then if you turn the page to the table at the bottom of page 53, that means FCA is 1340.
Yeah.
Yes. And then if we convert that to euro by looking at tab 6, page 75, that's 1180, yes? For December 2018.
Yes.
Which is exactly the same number as the respondent's employee, Ms. Hogan, identified in an internal email.
Why is it right to take CFA Europe rather than CFR Rotterdam?
So it's, sorry, FCA Europe.
FCA Europe.
As opposed to the Rotterdam.
As opposed to
I mean, they're
CFR.
both delivered prices, aren't they, in Europe?
Well, yes, only because the respondent's expert said that FCA, in his mind, was the closest comparator to X-Works, obviously in terms of the distribution of costs and things like that. Which I think is right, because X-Works, because CFR would be delivery to a named port of destination. CFR would be port of destination, whereas X-Works is factory, and FCA is named place. I mean, it could be is named place, which is closer to factory, I would say. And it's certainly what the respondent's expert said. So and it's actually in his supplemental report at paragraph 17. He says,
Where is this?
tab 6, page 73 of the supplemental bundle. Four lines from the bottom. The contract is ex Venlo, which is similar base to FCA. Both of these provide the cost of freight, etc.
So which paragraph? Second?
Paragraph 17 on bundle page 73 in the supplemental bundle. He's talking about the different Incoterms.
But the contract isn't just ex Venlo.
No, but if ex Venlo was chosen, which is what they had been choosing, the reality is there are two levels of uncertainty, if I can put it that way. First, there's the question of, can you imply a term at all? Yes? And in circumstances where there's no evidence, that it's extremely difficult to identify what the price is, then I say there might still be some disagreement at the factual stage, or the evidence might not be perfect. But at that stage, the judge has to do his or her best to identify what the reasonable or market price would have been at that stage.
I understand that submission. Can I just focus on something we haven't focused on?
Yes.
Which is what you mean by, at that stage, the judge has to. At what stage?
So,
I mean,
at the stage
after a dispute has arisen.
Oh, I see what you mean as to the mechanism. Yes. So if the parties are unable to agree, if it is appropriate to imply a term for a reasonable price, let's just say reasonable price for now, and that
the parties don't agree. They get to December of 2018, and they haven't agreed.
Yes.
and the buyer then says, well, I think the reasonable price is X. You, on the 1st of January, can I have my full 1,200 metric tons, please, plus the free trucks I'd be entitled to by reference to the price that I say is a reasonable one?
Yes, well,
What does the seller do? What's
Well,
the mechanism for resolving that in time for the parties to know what the delivery obligation is?
well, I mean, they could theoretically go to court, as they could theoretically go to arbitration in a clause a contract that contains an arbitration agreement.
But the cases where that's been regarded as a satisfactory mechanism
Yeah.
are cases in which it can all be resolved later by the arbitrator or by the court, because that will simply decide how much money has to be paid.
Yes.
In our case, because of the free trucks provision, the delivery obligation itself
Yes, I see that.
depends on the price being made certain. So if it's a case which you don't need an arbitration clause, but you can use the court, because, ignoring the Latin, something is certain if it can be made certain.
Yes.
It needs to be made certain by the 31st of December.
Well, in my submission, a reasonable price, or a market price certainly, is a certain price, even if the parties disagree on what it is. And the lack of a mechanism for identifying it in this case indicates that the parties, when they contracted, didn't consider it difficult to identify what that price was. And the evidence actually supports that. Because, as I say, in internal correspondence, my learned friend, an employee of my learned friend, identified the exact same number, 1180.
Well, the judge didn't accept that was a sufficient marker.
He didn't accept my apologies. He didn't accept that was a market price, that she wasn't necessarily talking about a market price.
Right.
But it is a remarkable coincidence that even though she wasn't even a sales side employee, she identifies the same number. And if one looks at the contemporary...
Sorry, but just... If you're right that it would have been obvious there was a standard approach to contracting, to calculating the price,
Yes.
so that both parties could, with certainty, have said to themselves on the 31st of December, we recognise that we've got to agree a reasonable price, we haven't actually agreed a price, but there's a standard approach which means you can pick a number. That's fine. If, on the other hand, as the experts appeared to be saying in this case, there is a range, how is that to be resolved in time for them to know what the delivery obligation is of the free trucks?
Well, I think, there might be some uncertainty. And, well, they're saying there's a range, but then they're saying there's a range generally, depending on what the Incoterms are. And then Mr. Appa says the closest comparator is FCA Europe. So he isn't saying it's narrowed it down immediately to a much smaller sort of disagreement, if that makes sense, potential disagreement or potential uncertainty. And at that stage, it is, if there was still disagreement about that, right, then I suppose the seller would simply have to, it would become a question of who's in breach of contract. You'd have to just deliver and then argue about it later. And I don't necessarily see why it's different to argue about volume delivered as opposed to price. You deliver, if you get it wrong...
Sorry to interrupt you.
Yes.
There might be this difference. Generally, the parties assume that their contract is capable of being performed,
Yes.
with them each being certainty as to what the performance is that's required. It would be surprising to attribute to the parties an intention that, if it be the case that there was some uncertainty about the number of free trucks that have to be delivered, then you'll just leave it to be decided in due course whether you were in breach in the number you offered.
Well, if we work through it, let's assume that there is an agreement for a reasonable price, and let's assume that the agreement is that and everyone knows you pay 70% of the FCOJ market price, and there's a disagreement about whether it's, 50 euros here or there, then presumably the seller would simply deliver what the buyer is willing to accept, and then they would argue about it later. So that would be exactly the same as arguing about a price later.
When you say argue about it later, the buyer says, no, I'm entitled to more by way of free trucks, and you're in breach of contract, and
Well, if,
I'm treating that as repudiatory.
well, and then it gets dealt with. And I mean, there are lots of situations in which the working out of a contract. So let's put it, the same exact problem would arise if the contract expressly said reasonable price. If the contract said a reasonable price or a market price is paid, that exact same problem would arise.
It would, but that would be because the parties had chosen that uncertainty.
But
Assuming it is an uncertainty.
But if we're
and then
implying,
that is the party's bargain. We're in a circumstances where you're saying it can be implied that was the party's bargain.
Yes,
we're looking at whether that level of uncertainty would be something that the parties can be treated as.
and in my submission, the easier it is to identify, the more common the approach, if you see what I mean, the more common the approach is, and the easier it is to identify.
Well, I quite understand that.
Yeah.
If there's no difficulty, or there's only a small difficulty
Yeah.
in identifying with certainty what a reasonable price is, this problem disappears. You
Yes.
don't need to go to the court to decide it.
And I say that's the case here, because the experts, the calculations are based on the 70%. And if you look at the contemporaneous documents, the emails, which are referred to in the appendix to the judgment, and I can take you there now. There are two from the 10th of December 2019 and the 17th of December, which are pages 130 and 131 of the core bundle. And what you'll see is this is the appellant doing exactly the same sort of calculation as the experts are doing.
This is the 10th of December, is it?
So 10th of December 2019, but they're still arguing about the December 2018 volumes, the price fixing for that. And I think it is important to remember that this is not a case where the parties were desperately trying to agree a market price. The respondent didn't want these goods. So the appellant kept suggesting things and the respondent kept saying, I don't want any of it. So here the approach is the same, and they come up with some numbers, which they then 7 days later drop. And what you see in the 17th of December email, which is at page 131 of the bundle, is that they've dropped to 1,200 euro per metric tons, apparently following a discussion with the respondent. We agree to take a minimum price of 1,400 and a maximum price, blah, blah, blah. And you get to 1,200 euro per metric ton. Do you see that? It's at page 131 of the bundle.
Yes.
Which is again remarkably close to the 1180. So there's no the truth is, this is not a case where there would have actually been any difficulty in identifying the price if the respondents had actually wanted any of these goods. So it's similar to the example Lord Justice Ricks gives in Mammoth Oil, where there were difficulties, but they were extraneous difficulties.
You said there were two uncertainties. There's the range, or it doesn't have to be a range, but a difference in price,
Yes.
depending on whether it's X works or not. I don't think that's a range. That's two different prices, isn't it?
Yes.
Where it's delivered. And the other was, appears to be a range of the percentage of the OJFC market price that you take. You say it was agreed that it was 70%. Where's the evidence that there was no range about that percentage?
So if one looks at, so the calculations are based on 70%. And then if one looks at tab 14 again of the supplemental bundle, which is my cross-examination of Mr. Appa, so the respondent's expert. And one looks there, so page 178. If you
Yes.
start at page 14, line 16, and it's fair to say, isn't it? and then go all the way to line 20 of page.
So you rely on his answer at 23.
Yes, and then over the page, I put to him it would be very unusual to, for example, have 50% or anything else. And that's at page 15, day 3, page 15, 1 to 21. Well, 22. And one of the key points is, of course, that this is a contract entered into in May 2018 with deliveries to be extended into 3 years going forward. And so if there was, for example, some supply or demand, specific supply and demand issue in December 2019, that's not something that is relevant because the buyers already agreed to buy a certain amount and the sellers already produced that amount for them. So in circumstances where the amounts subject to the free trucks mechanism are fixed on day one, even months before even the first open price is fixed, you know, sort of, it is really that 70% of the market price in December. So it would be December 2018 and December 2019.
But the range of prices we can see from the 1350 means that the free trucks element is quite a substantial. It's not just the odd bit extra. At 1350, I think on the 400 metric tons, it's an extra 74 metric tons. If you've got a price which is lower than that for the 800 in years to come, it'll be hundreds of metric tons.
Yes.
We're not talking about a sort of minor adjustment in quantity, and we're talking about a contract in which I think the judge found that one of the purposes of it having to be determined by the end of December was so that your clients could adjust their production accordingly.
Yes, I mean, they could
you're right
theoretically.
to my mind to say what one needs to look at is what the parties would have been in a position to determine at the end of December for the following year.
Yes, and my point is, I suppose that once you actually, so there are things that are not open to them anymore. So that it's not open to them to say, I want a different quality, I want a different amount, I want X, Y, and Z. Those things are fixed by the express terms of the contract for the full amount. So the only thing left to identify is the fluctuating market price for the FCOJ and then taking 70% of that. That's what I say was left. And that, I say, is reflected in the correspondence, to the extent that there is any correspondence from my side trying to agree that price. And once one looks at the expert evidence, it isn't a big range. It's actually very narrow range. And it is theoretically possible that there might be some agreement, and then the parties would have to come to court and resolve it. But it's not the sort of uncertainty that makes it unlikely for the parties to have intended that, if I can put it that way.
Right, now it's 12:30, just take a check of how we're doing.
Yes, sorry, let me just... If I could have 10, 15 minutes extra just to finish off, or do it after.
Well, Mr. Corby, unless you object, I will be minded to allow Ms. Larty to finish.
Of course.
We'll give you a few minutes before lunch to get your case out. Yes.
So the point I was coming on to, and I've actually covered some of my later points already now, so we won't need to come back to them. But I did want to highlight, as I've said, this is not a case where there's just an agreement for the 3,600 metric tons with the price for yearly amounts to be fixed latest by December the previous year. If one looks at the terms of the contract,
Yes.
There's an invoice price for the full amount.
Yes.
There's quality criteria for the full amount. There's a delivery period set for the full amount, and that's at clause 5, so January to December. So in other words, the amount sold, the quality of the product required, when it is required, which is where the delivery period comes in, have all already been agreed for the full 3,600 metric tons. So the things that might impact price outside of the fluctuating market price of FCOJ have all already been set. So, and that's also for the 800 metric tons. So the contract is not envisaging a full-blown commercial negotiation in December each year. It's a much simpler process that the contract is envisaging. And the other point is that the contract expressly states that the buyer is to give instructions for delivery 15 days prior to delivery. And the seller is not released from its obligation to make the goods available if the buyer fails to, is only released if the buyer fails to give instructions. So there's no provision in the contract saying, well, if you don't agree the price in December, then the seller is released. And that is again consistent with the parties not having in mind that there might not be an agreement in December.
Want just to show us that part of the, I don't remember, of course, if we did look at it, I'll slip my mind. Just look at the contract again.
So page 100 and tab 11 of the core bundle,
Yes.
page 192.
Yep.
Instructions for dispatch. The buyer should inform the seller 15 days prior to every delivery.
Yes.
Now, obviously, the delivery period is at clause 5, and it's January to December. So any time in January to December. And the buyer just has to give 15 days notice. I want the product now. And then quantity 3,600
Yes. All right.
in case that the buyer fails to instruct. So it's a reference back to clause 9.
So that at the time that the price is to be determined, by latest December, it won't be known whether the buyer is going to ask for it ex works in Venlo, in bulk or in drums. It'll be more expensive if it's in drums, or in Ghent. There has to be a price that's determined to be a reasonable price, whichever of those options is subsequently chosen.
Yes.
And those options will affect the cost to the seller. Is that
Well,
fair?
I think the reality is they always went, I think, for X Works Venlo. But yes, I accept that that is a potential other uncertainty in the sense.
And in not small amounts. I mean, we've seen what the experts have said about the price of drums, for example. It's something between $70 and $150 a ton or something like that.
But those prices. So the list at paragraph, I think it's 124 of the judgment, which comes from the appellant's expert. And Mr. Appa, the respondent's expert, doesn't mention any of those things because, as I've shown you in the cross-examination, he accepts that those sorts of costs are already inherent in the Incoterms. So,
Well, and just forgive me, Venlo is in the Netherlands, is that right?
Yes, yes.
So one might, and I don't know how close it is to Rotterdam, but one might think that that's quite close to a CFR Rotterdam price, whereas the delivered duty paid addresses are somewhere in Ghent, Citrosuco in Ghent, is that right?
yes, I think what they're envisaging is that in December there will be a conversation during which the price is fixed. And at that point, the buyer will know where it wants the goods to be delivered. I think this is what the contract envisages. So there is an element of cooperation, clearly, that needs to go on in order to make this contract work, even in relation to the 400 metric tons. So, well, not the price aspect of it,
That's all done and dusted, isn't it?
but in terms of delivery schedule and things, is my point. So they are discussing delivery schedules and things like that.
They'd have to. I can just say, I give you here 15 days notice. I want it in bulk at Venlo, or I want it in drums, duty paid in Ghent.
But just if we just look at let's look just
But
at
is that right as a matter of contractual entitlement?
what that they can
That the
say.
buyers can simply do. They can simply serve their 15-day notice, and they say this is where we'd like it delivered.
Yes.
There's no obligation to discuss earlier where they're going to ask for it. I mean, they may do as a
No.
matter of
Which which I would say indicates that when the price of 1350 is set, they have in mind a particular delivery, but are giving themselves freedom for other options, and taking the view that those other options won't change the price.
No, and that's a price that lasts for 3 years. So who knows what the circumstances will be in year 3 at that stage.
Well, but that's why only part of it is fixed, right? So they're not commercially willing to take on the market fluctuation risk. But I do think that so what this contract, if you just look at the contract, what they are clearly envisaging is a relatively straightforward process in December where the price is fixed by reference to the market conditions in December, and then they fix it for the following year. And at that point, they will have in mind which of these deliveries they have in mind, and the price will be fixed by reference, presumably, to that. But they're all in Europe. I see the point about the drums and the bulk being different. I do. I think in reality it was always in drums. But in terms of contractual construction, it's not envisaging a full-blown commercial negotiation.
I understand that.
And as Lord Wright says in Hillas, businessmen, they're not sat there thinking, well, what if this happens, and what if that happens, and what if this happens, and what if that happens? It's a pretty sort of rough and ready process. It's not a long contract, and they're not drafting with all the potential difficulties in mind. They're understandably assuming it'll be a straightforward process of taking 70% of the FCOJ price, and off we go. But certainly this contract does not release my client from the obligation to produce goods if no agreement is agreed in December, if no agreement is reached in December. And similarly, I would say the lack of an arbitration clause or an other mechanism for identifying or resolving any difficulties, in fact, supports my case because it envisages a straightforward process. It's
You say that that if there had been a complexity, the contract would have included an arbitration
Yes.
clause or some other.
Or some. I don't think an arbitration clause would be any quicker to resolve than the court.
But some concrete.
Yes. And the fact that there is no concrete mechanism is at the very least consistent with my construction and my understanding of this contract, which is that what was envisaged was a straightforward identification of the price. And there might be some disagreement around the edges, but nothing that the parties didn't consider could be easily resolved.
But the contract is silent about it.
Well, the contract doesn't release my client from the obligation to produce the product. It does set quality, etc. criteria for all of the volumes, etc., etc. So that's all consistent with it being envisaged to be a straightforward process when the contract was entered into. And then what happens is the respondent doesn't want the goods. So then it becomes complicated, not because it is hard to identify the price, but because they don't want the goods anymore. But certainly just looking at the contract, if complexity in ascertaining the price had been envisaged, there would either have been a mechanism to resolve it, or my client would have been released from its obligation to provide the product if no agreement was reached, which would have been in line with a contract that envisaged no agreement being reached. Because
if it was straightforward to do, why didn't the contract include, set it out what it would be? Why didn't it say 70% of market value of the COJ? In
my submission, that's probably what people who contract in this trade think they are doing. So that is the point that is made in.
Was there evidence of that? Was there evidence? You've said that's what you've just asserted. That's what people thought they were doing.
There was evidence of the 70% was in the correspondence both before and after the contract. 70% is not a sort of made-up figure. No. It is the sort of even the experts agree. It's certainly the start. It's what you do.
The starting. I think one of them says it's the starting point for a negotiation.
Yes, but what they're envisaging is a full-blown commercial negotiation. So I can quite see that if someone says, well, I don't like the quality of your goods, I'm going to pay less. Or I don't like you as a seller, so I'm going to pay less. but we're not in that world because those things have all been set. Let me just see where I've got to. Yes, and then my fifth point was the free trucks mechanism. So judgment paragraph 9, the judge does accept that the two men who negotiated this particular contract did understand the free trucks mechanism to be a way to adjust for market fluctuation. And my learned friend says that's not how the judge said that the free trucks mechanism was used in the context of, shall I take you to that paragraph in the judgment?
You rely on the judgment of paragraph 9.
Paragraph 9. There is no reason to doubt that Mr. Landsbergen and Mr. Caden each understood it to mean, as defined by Professor This.
I have some difficulty with that, partly because he rejected Professor Vatoukas' evidence as to what it meant, which, as subsequently developed, was that it was an optional matter, and secondly, and perhaps more fundamentally, that in relation to the 400 metric tons,
yes, I see
it plainly is not such a mechanism.
Yes, I think, like all contracts, there are various sort of negotiations and drafts floating around, but the basic premise is that when they were talking about the free trucks mechanism, these men understood it to be a way of adjusting for market price. So again, it's not perfect. I fully see that it doesn't work for the 400 metric tons.
Well, if they were using it for the 400 metric tons, and it was not in those circumstances a mechanism for choosing a market price or accounting for fluctuations in market price, why should the same mechanism, free trucks, be seen as a marker of an intention that it should be market price for what was not agreed?
Yes,
there seems to be no logic in that at all. As far
well,
as I can see.
I do see that. And as I say, this is not a major point for me because I think the commercial purpose is in any event clear from the fact that there's an undoubtedly intention to contract for the full amount, the fact that it's a long-term contract with deliveries going into the future, the fact that the price of wesos is linked to a fluctuating market price.
Yeah, you've made all these points. I'm just on your fifth point that the pre-trucks.
Yes, I think the only
points in the same direction.
Yes, and I think all I would say is it certainly, at most, it points in the same direction because this is how the men who negotiated the contract understood the concept, even though they clearly were not using it in that way for the 400 metric tons, because the price for that ended up being fixed on day one. But I don't take it further than that.
Thank you.
Right, that's your fifth point, was it?
Yes.
I think
Yes.
there were 5.
There were 5, and that was my fifth and least important point. So
As it turned out.
Yes, that's why it was fifth.
that's why it was fifth, exactly. The only thing I would just point out is the finding at paragraph
In the judgment.
1, 2, 3 of the judgment, so tab 6, page 114 to 115. The very fact of the express term that price be agreed would allow either party to pursue their own commercial ends. That's wrong.
Sorry, I missed where the paragraph was.
Paragraph 123, tab 6.
Yes, got it.
Yes. But I won't go through all of that again. He's basically not engaging with what Lord Justice Ricks tells him to do. So looking at the long-term nature of the contract, his previous finding, etc.
I think you covered this in your schedule.
Yes, yes. So I should briefly say, I've got very limited time, so let me see what I will prioritize. So insofar as I don't have the SOGA section 8.2, the benefit of that implication, I say I can imply the same term as a matter of fact. And it's essentially the same 5 points I've been through that give rise to that implication. So contractual intention for full amount, etc., fluctuating market price, etc. And I think the judge's reasoning, it's the uncertainty point, which I've already touched upon, the evidence on that. But I would also remind your lordships that the test is of reasonable certainty in the context of giving effect to so you're striving to give effect to this contract. This is not a sort of bare textile situation where there's a question whether there is a contract or isn't a contract. In this case, there is undoubtedly contractual intention in relation to the full amount. And so the court has to strive to give effect to it, looking for, Viscount Mom says in Scammell, a reasonable degree of certainty, and to use Lord Wright's phrase in Hillas, not too astute or subtle in finding defects. Then I've made the point that there are objective criteria. So what one is looking for is those objective criteria, and I've been through the evidence on that. I might have to address 124 very briefly, which is the points at A to D at paragraph 124 of the judgment. So packing costs, transportation duty, etc.
Yes.
And as I say, these come from my expert's report. They're not mentioned by Mr. Appa at all.
Your point is they're not material variables.
Well, they're either not material variables, but they're also already, apart from possibly exchange rate variations, reflected in the Incoterms. And in that paragraph from my cross-examination, Mr. Appa accepted that. So tab 14, page 177, day 3, page 11.
Yes.
I put to him, basically, you didn't mention any of these things in your first report, and that's because they're already reflected in the market price. And he says yes. So these different market prices reflect the fact that costs like transport, duties, freight, packaging, yes, will either be borne by the seller, yes, depending on the type of contract. So those are not relevant uncertainties. Factually,
Yes.
and then the uncertainties at 125 of the judgment, so that's page 115 of the core bundle. I say those are not the sorts of points that were open anymore because the amount sold, delivery dates, quality criteria for the full 3,600 metric tons had already been fixed. So it was no longer open to the buyer to say, well, actually, I've changed my mind, I want less, or I want a different quality. So insofar as, for example, the quality of goods could impact on the price, that was no longer sort of on the table anymore when it came to fixing the price in December each year. And the only one that I think needs to be picked out is the supply and demand in the wesos market. And I think the short answer to that is that wouldn't be relevant in a contract where you fixed at the start and then you're producing over time. Because you're producing for a particular buyer. And then if I can have 2 minutes to just address the reasonable versus market price point.
Yes.
Which is that, as I say, there was always a question in this case about whether the implied term is appropriately described as reasonable or market price. I put reasonable first and market as an alternative. And that's because the price was linked to the price of a traded commodity with a published market price.
Yep.
And as I say, it was always part of my case that there was no available market. And one can see that, and I'll just give you the references at paragraphs 19 and 20 of the reply, which is in the core bundle, tab 10, pages 187 and 188. And section 50 was at issue, section 50 of the Sale of Goods Act was at issue at trial because the appellant was left with quite a lot of wesos and so had to offload it. And in that context, the judge said there was no available market. In that context, the respondent said there was an available market, and that's in the defense at paragraph 41, subparagraph 3, core bundle, tab 9, page 175. But so it's not a question, as my learned friend says, of me resurrecting the argument. It's just there was always this tension. And so if your lordships accept that there's sufficient certainty, then because there are sufficiently objective criteria or a standard way of calculating the price for wesos, then reasonable price is probably the better way to describe it.
Right.
And that's it. I shall leave it there.
Thank you. I'm just, Mr. Corbett, can I just check I've understood your answer to the question I asked earlier, which is what do you say the judge should have taken as the reasonable price? As I understand it, for December 2018, for example, in which at supplementary page 75, we've got Mr. Apper's figures in euros.
Yeah.
It is the bottom of that, 1180 euros, because that represents the FCA Europe.
Yeah, so it's 11880, yes, and then same for December 2019. Alternatively, it's the middle of the range, euro 1180 to 1365, 971 to 1059. Because Mr. Apper said it would be the middle of the range. But I think actually when you look at the data, it is 1180 because there was no data for the lowest range in December 2018.
I understand.
Thank you. Thank you very much, Mr. Lottie. Now, Mr. Corbyn, you've got 10 minutes to set out your stall.
Thank you. The shredded slot just before lunch to try not to return to the pavilion. My Lords, I'm going to address grounds 1A and 1B from the grounds of appeal in that order. I'm not going to address ground 2 separately, as it's just sets out reasoning that goes to grounds 1A and 1B. In respect of those two grounds, I'm going to spend most, if not all, of my time on ground 1A, the reasonable or market price ground, and very little time on ground 1B, the reasonable endeavours to agree term. As both of those grounds, ground 1A and 1B, raise questions of construction and implication, and the grounds of appeal are put in both terms as a matter of construction and implication, I'm going to deal with the construction of the contract first when I deal with each ground, and after that I will turn to the question of implication. And I've set out in my skeleton argument in paragraph 16 what Lord Newberger said in Marks and Spencer's about that being the correct approach to address these sorts of questions. For obvious reasons, one addresses construction first to see what the express terms are before deciding whether a term can be implied, and also one determines the express terms first to see whether the cardinal rule that no implied terms can contradict the express terms will be breached. And so, as I say, I'm going to start with construction, my Lords, and if I could ask your Lordship to turn up the grounds of appeal. I apologise if this causes confusion, but I've been using the grounds at tab 5 of the core bundle, page 77, which are the grounds as they were attached to the order of His Honour Judge Pearce. And turning now to ground 1A, on construction, the case is that the judge failed to find that on a true construction of the contract, the parties agreed that the reasonable or market price was to be paid in relation to the 800 metric tonnes per year. And just pausing there, that as a case on construction is not saying it was a reasonable or market price if they failed to agree. It's saying straight up it was a reasonable or market price, nothing about the parties agreeing. So it's put, this is not a default term, this is put as a matter of construction, there's nothing about agreeing. And that's the case I intend to address first. If I could ask your Lordships to turn to the contract, which is at tab 11 of the core bundle, and look at page 191. The key provision in this case is clause 5, and in particular the penultimate two lines, starting with the words 800 metric tonnes at open price to be fixed, latest by December of the previous year, what I've referred to as the open price provision in my skeleton argument. And in a nutshell, the issue of construction raised by ground 1A of appeal is whether, on the one hand, as the judge held, and I submit and as KSY used to accept, the contract contained, at least in the first instance, an agreement between the parties to agree the open price for the 800 metric tonnes, or whether, on the other hand, as KSY now says, that the open price provision did not provide for the parties to agree the open price at all, but rather expressly provided simply for the open price to be a reasonable or market price. In my submission, the judge's construction was correct. If I may start by showing your Lordships how the judge construed this provision. Turn to tab 6. Page 112. The starting point is that at paragraph 114, the judge dealt with the correct construction of the words open price, But he did so in the context of the appellant's primary argument, which was rejected below and has not been raised on appeal, which was namely that if the parties failed to agree a price, then lo and behold, the invoice price applied. The judge rejected that argument, but in doing so, he gave his construction of the words open price. In the second sentence there, he says, there is simply no basis for concluding that the word open means anything other than a price to be fixed by agreement between the parties by the mechanism set out in the contract, namely the parties agreeing the price by the latest in December of the preceding year. And if I ask your lordships to turn forward to paragraph 118, the judge then set out his composite construction of clause 5 of the contract. Turning over the page at page 114, and he said, in respect to the 400 metric tons, the way the contract was to work was that there would be an invoice price of 1,600 metric tons for the 400, but in order to achieve the effective price of 1,350 metric tons, additional free volume would have to be provided. And in substance, he construed the provision as to the 800 metric tons in exactly the same way, the only difference being that the effective price was going to have to be agreed between the parties.
Looking at those words alone, ignoring the rest of the contract for a moment, wouldn't it be said that 800 metric tons at open price to be fixed is no more than an express term that it should be fixed, without identifying how it should be fixed?
Yes, my lord, I'm going to come on to address that exact point. If I may, I say as a matter of language, that would be wrong. A matter of language of the open price provision. And I say that for 4 reasons.
Well, it's 1 o'clock now. Sounds like quite a lengthy submission. I think the umpire is being generous and rising a little early.
I'm grateful, my lord.
We'll resume at 2 o'clock. Thank you very much.
Court rise if may, Lord.